Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan, and we're going to continue our video series designed to educate our viewing audience out there, so please subscribe to our channel. Today we're going to talk about assets. You know, in a divorce, everybody is accustomed to the notion that we divide assets. Very little time is spent on defining what an asset is, and it becomes important because a member of our viewing audience asks us, what happens if we bought assets during the marriage, but we titled them to my in-laws? So, you know, there aren't that many assets in life that are subject to a title. I mean, you're talking about a house or a car, maybe a couple other things, as securities can be put in someone's name, etc. But let's say we're talking about that there's a house purchased, but put in the name of one's in-laws. I guess you got to ask yourself, why on earth would somebody do that? Maybe there were credit issues, maybe there were other things that caused them to do that, but the question is, what is the legal impact of doing that? And can the house now, in the context of the divorce, be regarded as something that should be split? I mean, after all, it makes it look like the title, at least, that the property belongs to someone else. Someone who's not a party to the divorce. Well, you have to remember one thing. The divorce courts are courts of equity. The court is going to try and do what is fair in order to make sure that the ultimate resolution makes sense. So the court will try to do that. If the property, though, is bought and put in someone else's name, the question then becomes, was it actually treated as your property or their property? The court is going to look at that. So, for example, I mean, if it was some sort of gift, was it handled as a gift for the purposes of income tax, which is one thing to look at. Another thing to look at is, where did the seed money come from to buy the darn thing? Who's paying the mortgage? And if there's mortgage interest or the maintenance or the things, how is that being handled in terms of taxes and other things, if applicable? In other words, the court will look beyond the document as a function of equity to try and figure out whether or not it is in fact a marital asset. But you're going to have an uphill battle. You're going to have an uphill battle because it makes it look like you guys bought a gift. You gave it to your in-laws. Now you're getting divorced and want it back. I mean, it could be convincingly argued that you don't get it. And there's usually in these situations not documentation that says it's really ours, but we're putting it in your name, and here's the reason why, etc., etc. So I would say that it's not impossible to have the court sort of go beyond it and say, okay, we're not changing the title. The title's already out there, but we can take the value, we can regard the value as a marital asset for one purpose or another. But be aware that that is going to present some serious evidentiary challenges as that case moves forward. If you have any questions about that, reach out. We'll be glad to help you out.